Mr. Chauvin, you and I have had several discussions throughout the course of my representation of you relevant to your right to testify or to choose to remain silent, correct?
That's correct.
And during the course of our representation, it's fair to say that you and I have had this conversation multiple times, correct?
Correct.
You understand that you have a Fifth Amendment privilege to remain silent. Do you understand that?
Yes.
Do you understand that if you choose to exercise that right to remain silent, neither the state nor the court can comment on your silence as a sign or an indication of your guilt? Meaning they can't say he didn't get up and defend himself, so equate your silence with guilt. Do you understand that?
Yes.
All right. Now, you also understand that you can waive that right and testify. Do you understand that?
Yes, I do.
You understand that if you chose not to testify, or if you did in fact testify, you would be subject to cross-examination by the state of Minnesota.
Yes.
You understand that if you were cross-examined by the state, we could not attempt to limit the scope of your testimony. The state would be given broad latitude to ask you questions. Do you understand that?
Yes.
We've had this conversation repeatedly, correct?
Correct.
I have repeatedly advised you that this is your decision and your decision alone, right?
Correct.
I have advised you, and we have gone back and forth on the matter, would be kind of an understatement, right?
Yes, it is.
But after a lengthy meeting last night, we had some further discussion, agreed?
Correct.
And have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
Mr. Chauvin, I'm going to address you directly because the decision whether or not to testify, take this off, is entirely yours. In other words, it's a personal right. Mr. Nelson makes a lot of the decisions in trial, but one he cannot make for you is whether or not you testify. And he can give you advice, and you can take that advice or reject that advice. But the decision ultimately has to be yours and not his. Is this your decision not to testify?
It is, Your Honor.
All right. Do you have any questions about your right to remain silent or to testify on your own behalf?
Not at this time, I don't.
All right. Does anyone promise anything or threaten you in any way to keep you from testifying?
No promises or threats, Your Honor.
Do you feel that your decision not to testify is a voluntary one on your behalf?
Yes, it is.
Now, in addition to that, I'm convinced then that this is your personal decision and that you are aware of your rights, but there is a jury instruction that may be read to the jury. This, again, is the one that you get to weigh in on. It's not for your lawyer to make the decision. Again, he can give you advice, and I don't want to know what the advice is, but you can accept the advice or reject the advice as to whether or not to give this instruction. If you would like, I can read this instruction to the jury. It's titled, Defendant's Right Not to Testify. The state must convince you by evidence beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant has no obligation to prove innocence. The defendant has the right not to testify. This right is guaranteed by the federal and state constitutions. You should not draw any inference from the fact that the defendant has not testified in this case. Do you understand that instruction?
Yes, Your Honor.
Would you like that read to the jury?
Yes, Your Honor.
Have you had enough time to talk to Mr. Nelson about whether that's a good idea or not?
I have, Your Honor.
All right. And so I will read that to the jury on your request.
Thank you.
All right. Anything else regarding the defense case before we proceed to talk about rebuttal? All right. We'll have you rest in front of the jury then.
All right, not necessarily a surprise. It's never a surprise if the defendant doesn't testify. I mean, some people are speculating that he might, but I didn't see much upside for him testifying because it's really difficult as a prosecutor when you don't have many of his words to work with to prove his state of mind, whether or not he had intent to assault. Let's bring in Court TV legal correspondent Julia Janae, joins us from Minneapolis, Minnesota tonight. Julia, remind us and me how much this jury has heard from Derek Chauvin himself, like him talking and saying something about what happened that day, whether it's during the course of it happening or afterwards.
They really have not heard a lot, especially if you contrast that with the other officers who were on the scene. Derek Chauvin, when he arrived, you don't hear a lot on his body camera of him saying things. He has a few phrases here and there, but he's not ever talking to anyone. You don't hear him talking to the officer at the very end. He just has a little bit with a lieutenant who's questioning him about what happened. And he said that there was a guy who was on drugs and we had to hold him down until the ambulance got there. But in the totality of everything that they've heard as far as evidence and the people that they have heard testify, they heard very little from Derek Chauvin. Today is one of the first times we've heard him even in court outside the presence of the jury.
That's true. That's true. Haven't really heard him speak much at all. Very, very minimal. And I don't think they wanted to risk it today by putting him on the stand, because then he's got to talk, and you can get into his mind a lot easier that way than through the other evidence in this case. The jury's not in the courtroom when all this happens. They have no idea what's going on. They'll hear that charge during the instructions. But who was in the courtroom when he made this decision?
Well, the judge, of course, and all of the parties there. We understand that Stephen Slisher was going to be the one who would cross-examine him if he did decide to take the stand. There was also a supporter for him, a female supporter that was in that chair that is reserved for Derek Chauvin. And the family member for George Floyd had not entered the courtroom yet, but later he was asked. Arthur Reed, a cousin of George Floyd, asked about his reaction to Chauvin not taking the stand, and he said that we expected it as a family because we knew this state prosecution is so good that they would have cut him apart, essentially, if he had undergone that cross-examination.
All right, let's bring our special guests into the conversation. Joining us now, civil rights attorney, former Court TV anchor Lisa Bloom is with us. And in Atlanta, Georgia, even though it looks like he's perhaps in Margaritaville tonight, is Superior and State Court Judge, the Honorable Gino Brogdon. Great to see you, Judge. Great to see you, Lisa. Lisa, was there any upside for Derek Chauvin to get on the witness stand?
Listen, I think he's going to be convicted. And I think he's going to be convicted of one of the top two charges of murder. So I think he should have testified. I'm probably in the minority. I don't do criminal defense. I represent victims in civil cases, mostly sexual harassment cases. But I will tell you, I think he had very little to lose, and he could have taken the stand and he could have said, I regret that
Well,
George
let me ask you
Floyd
this,
lost
though,
his
Lisa.
life, but I was following the policies, and I certainly never intended for him to lose his life.
Let me ask you this, Lisa. In your cases, civil cases, the defendants testify a lot, don't they? The accused.
Yes, they do, and I get to cross-examine them, and that's
How
the
do
most
they
fun
hold
part of
up?
my
Be
job.
honest. How do they hold up, Lisa? They don't hold up so well when you're cross-examining them, do they?
Not so well, but listen, he's looking at potentially the rest of his life in prison. He's got very high stakes here. This is more than just about money, which is what my cases are about, right? And I don't know if his attorney has accurately conveyed to him how badly this trial has been going for him. That's the issue to me.
All right, I understand what you're saying, and that may make it makes a lot of sense, because a lot of people think this case is very one-sided at this point. Judge, in your years, I mean, not that many defendants take the stand, but this is a defendant who can take the stand. He has no priors. He's been a law-abiding citizen for his life. But what are your thoughts about what happened today?
I think he had everything to lose and not an ounce to gain. Vinny, the defendant in a murder trial rarely will take the stand because they're going to say something trying to exonerate themselves, and this is on direct. You get these skilled prosecutors on cross, they're going to slice and dice this guy, even if he was the best guy. But a guy like this who would commit a crime like this, you can imagine he's not real agile when someone's in his face. He's a guy used to being in control. So you get one of those prosecutors in his face and they ask him the big question. Why did you do this? The answer doesn't matter. His words become a noose, and he is surely convicted of the highest charge. That's his task here in deciding not to testify is an effort to try to get the lowest charge. He's going to be convicted, but if he were to testify, he'd be convicted of second-degree murder.
All right, let's talk about second-degree murder. Let's put it up on the screen. Murder in the second degree in Minnesota. What is it? Here it is. Causes the death of a human being without intent to effect the death of any person while committing or attempting to commit a felony offense. Okay, this is like felony murder in other jurisdictions like Georgia. Let's take a listen to the argument that was made, because there's a big disagreement about the jury instruction, the jury charge here. Let's take a listen to a prosecutor who was phoning in, part of that 14-member team, Sundeep Iyer. Take a listen.
We'd asked for a revised definition of assault, which of course relates to the second-degree murder charge. As written, the state believes that the instructions suggest that the defendant must have a purpose to inflict or cause bodily harm in order for the defendant's conduct to constitute an assault. That would be legally incorrect, and in fact, that was the very argument the Minnesota Supreme Court rejected in Dorn. The Minnesota Supreme Court held in Dorn, which is at 887 Northwest 2nd, 826, and Fleck, which is 810 Northwest 2nd, 303, that assault, quote, only requires proof that the defendant intended to do the physical act, quote, of committing a battery, without proof that he meant to or knew that he would violate the law or cause a particular result. In other words, the state doesn't need to show that the defendant had an intent to cause bodily harm. And we therefore requested that the court clarify the definition of assault by adding the following two sentences to its definition of assault. I'll read them for the record. Quote, the intentional infliction of bodily harm requires proof that the defendant intentionally applied force to another person without that person's consent, and that this act resulted in bodily harm. It does not require proof that the defendant intended to cause bodily harm, or that the defendant knew that his actions would cause bodily harm. And that language is drawn largely from Supreme Court's decisions in Dorn and Fleck.
Before you go on, I just wanted to clarify the state's position regarding, in the definitional section, the court defined assault as either assault harm, intentional infliction of bodily harm, or intent to create fear of imminent bodily harm. Is it the state's preference that I exclude the second alternative, essentially the assault fear definition?
Your Honor, I believe the court's definition of assault did not include assault fear. It only included assault harm. It said assault is the intentional infliction of bodily harm upon another, or the attempt to inflict bodily harm upon another. So while the state believes that if assault fear were implicated, then there would be a different intent standard. Here, this is an assault harm case, and so assault harm is a general intent crime.
All right, just wanted to clarify that. Thank you.
We got to unpack this a little bit, Julie, Janae. This definition of assault, right? Because they've got to prove an assault to get the felony murder, right? So to get that second-degree felony murder, they've got to prove assault. Where does this definition of assault, intentional infliction of bodily harm, where does that come from?
That is in the statute, but the way that they are talking about it there on the record is in the proposed jury instructions that either side has sent in, and that the court has actually provided some standard ones. So they're trying to reconcile what the jury is going to be instructed on. And it's critical because they want to throw out the intentional part, which would be the only one of the three charges against Chauvin.
Am I getting this right, that the state is arguing that intentional infliction of bodily harm does not require intentional infliction of bodily harm? Because that's what I heard.
They are saying that yes, they are going based on case law. The Minnesota Supreme Court found in a case, State v. Dorn, involved a woman who pushed the victim twice in the chest, and that victim ended up falling into a bonfire and sustaining some really bad burns. And in that case, on appeal, the Supreme Court held that she was still guilty of assault, even though she didn't intend for that person to suffer those very serious burns, but she intended to push. So they're saying, in this case, the act of Derek Chauvin putting his knee on George Floyd's neck, as long as he did that intentional act, even if he didn't intend for it to hurt anyone, that still meets the requirement for assault, and in this case, the second-degree unintentional murder charge.
All right, I just got to get a reaction here. Lisa Bloom, you make the argument. How is intentional infliction of bodily harm not intentional infliction of bodily harm.
Well, if you put it like that, yeah, it's a mind twister. But what I understand the court is saying, and Julia knows better than I do because apparently she's read the law and read the cases, but
Oh, yeah.
it's the intent to assault, not the intent to cause the harm.
Okay,
and
all right.
the idea is that the
We're running out of
officer
time.
intended the assault.
We're running out of time. Judge, give me the ruling. I only have like 20 seconds here.
The jury's going to go by how they feel about the evidence. These instructions are nice for us lawyers, but that stuff's going to go right over their head. So that's what'll happen.
All right, all right, all right. Lisa and the judge are staying with us. Julie Janae, we will speak again at the top of the hour. Thank you so much. Wow. We'll find out what the ruling is on all that tomorrow. When we come back, there's another big story happening in Minnesota, and we'll get to the bottom of the shooting of Dante Wright, the charges against the now former officer. That's all coming up next.
Y'all see the difference? This is a taser. This is a taser. But no, my nephew was killed with this, a Glock. These two are hurting, our family is hurting, our blood has been spilled, and all we ask for is to please just keep getting his name out there, and please help us to go ahead and get something done, a conviction, something.